So here we're looking at a case, taking a look at Canada versus GlaxoSmithKline. What is your view on the transfer pricing method used, the resale price method by GSK, and the ruling by the tax court that the cup method was the most appropriate? So I'm just going to give you an overview of it, and what I will also do is provide you with a link to the case summary that we did for this, so that you can just read through the case summary. Dr. Erasmus did the case summary as well on this particular Canada versus GlaxoSmithKline case. So this case revolves around the appropriate transfer pricing method for transactions between GSK Canada and its related non-resident supplier, Adecha SA. Sorry, I'm not sure how to pronounce that word, Adecha SA. The dispute specifically focused on the price paid by Glaxo Canada for ranitidine, the active ingredient in Zantac, and whether that price reflected an arm's length value. So Glaxo employed the resale price method, or RPM, to determine its transfer prices. This method starts with the resale price of the finished product, in this case Zantac, and subtracts a gross margin to arrive at the transfer price for the raw material, ranitidine. Glaxo aimed to retain a 60% gross margin on the resale price of Zantac, allocating the remaining 40% to the cost of ranitidine. Sorry. For example, if Zantac sold for $10, the transfer price for ranitidine would be $4, leaving Glaxo with a 60% markup, obviously. The tax court in Canada, however, took issue with this approach and concluded that the cup method was the more appropriate choice. The cup method compares the price charged in the controlled transaction with prices observed in comparable transactions between interdependent companies or parties. In this case, the tax court compared the price Glaxo paid for ranitidine to those paid by generic pharmaceutical companies in Canada, such as Apotex and Novopharm. So these companies purchased ranitidine from independent suppliers at a much lower price than Glaxo. Based on this comparison, the court found that Glaxo was paying significantly more than what would have been reasonable in an arm's length transaction. But that's not the end of the story there. So the case was taken to the Supreme Court of Canada, which acknowledged that transfer pricing is not an exact science. So the court emphasized that the selection of the most appropriate method depends on the specific circumstances on each case. In reviewing the tax court's analysis, the Supreme Court pointed out a critical oversight. The tax court had failed to consider the broader business context, particularly the licensing agreement between Glaxo and its parent company. This agreement granted Glaxo the rights to use trademarks, patents, and other intangible assets associated with Zantac, which likely influenced the pricing of ranitidine. So the Supreme Court did not decide whether the cup method or the resale method was the correct approach, but instead sent the case back to the tax court for reconsideration and instructed the lower court to factor in all relevant agreements and circumstances, including the license agreement, to arrive at a transfer price that better reflects the arm's length principle. So, I mean, going to your question, so this case highlights several important points about transfer pricing. Glaxo used the resale price method, the use of the resale price method was based on its specific business model and unique benefits conferred through its licensing agreement. The tax court's preference of cup was understandable given the seemingly stark price difference that Glaxo's randomized purchases were and those of the generic competitors. But the Supreme Court's intervention underscores that comparability is not just about finding similar transactions, it also requires a deeper analysis of the contractual and business framework that influences the pricing. So ultimately, the Glaxo case illustrates the complexities of selecting a transfer pricing method. It shows that rigidity, applying a single method, without fully considering the business context can lead to flawed conclusions. So in this instance, Masa, I would suggest that companies should, I mean, Glaxo would have known that by doing the studies. And for me, I would suggest that that should have been included as a study in their documentation to highlight why their pricing is really different to those of the generic competitors. So that's the suggestion that I would make on this basis.